You're reading a bar exam fact pattern. Two parties shake hands on a major deal. Everything looks locked in. Then one party backs out, claiming they don't owe a dime because absolutely nothing was put on paper. That specific excuse is the defendant invoking the Statute of Frauds. They are arguing the agreement is legally unenforceable without a written record. By the end of this video, you will have a step-by-step essay template designed to extract maximum points from any prompt testing this defense. Passing the bar requires you to present the law in the exact sequence the grader expects. We are going to build that sequence right now. The most frequent errors students make on these questions is jumping straight into the Statute of Frauds analysis. You have to lay the groundwork first. Look at this document. Your very first header must always be Law Applicability. Under this header, establish the threshold test. Article 2 of the Uniform Commercial Code applies to contracts involving goods, while the common law applies to services and real estate. Once that is set, add your second header, Contract Formation. Here, you must briefly prove two sub-elements, mutual assent and consideration. We do this because the Statute of Frauds is a defense to contract formation. You cannot apply a defense to a contract that does not legally exist yet. Proving these chronological prerequisites early on signals to the grader that you are tackling the problem systematically. Now you are ready for your third major header, Statute of Frauds, Trigger. In this section, you are answering one central question. Does the law require this specific contract to be in writing? To answer that, use the M.O.U.S.E.R checklist. It covers the 6 contracts triggering a statute: marriage, the 1-year provision, UCC goods, suretyship, executor, and real estate. Pay close attention to the 1-year provision. This is a highly tested trap that catches many students. The rule is triggered by absolute impossibility, not probability. It only applies if there is no possible way the contract could be performed within 1 year from its making. For example, providing personal instruction for 5 years does not trigger the statute. The performing party could die tomorrow, fulfilling the contract within a year. Internalizing the M.O.U.S.E.R list ensures you won't overlook a hidden trigger buried deep within a complex fact cavern. If the contract does trigger the statute, move to your next subheader, Satisfaction by Writing. To satisfy the statute with a physical document, the writing must meet 3 requirements. It must be signed by the party against whom enforcement is sought, it must show a contract was formed, and it must contain the requisite terms. Those requisite terms depend entirely on your gateway issue. The common law requires parties, the subject matter, the quantity, and the price. The UCC only requires the parties, the subject matter, and the quantity. If there is no valid writing, create your final alternative subheader, Satisfaction by Performance. For services under common law, only full performance satisfies the statute. For real estate, the buyer must complete 2 out of 3 actions: possession, payment, or improvements. Finally, for UCC goods, utilize the pause exceptions: performance, admission, written confirmation, or specially manufactured goods. By memorizing the strict writing rules alongside these specific performance exceptions, you can systematically dismantle a defendant's Statute of Frauds defense on the page. Let's review the complete framework shown here. You start by determining law applicability, you establish contract formation, you check the trigger using M.O.U.S.E.R, and you test for satisfaction using pause. You now have a comprehensive logical flow. This sequence matches the grader's rubric exactly. To lock this in, pull up a practice prompt featuring an oral agreement for goods over $500 and apply this outline right away. Utilizing a systematic outline removes the guesswork and turns complex contract law into a predictable process for securing points.